A student taking a medieval philosophy course mentions that they are studying philosophy now as an undergrad and intending to become a lawyer later. I see this and I feel compelled to respond to this student since I am indeed someone who earned a philosophy undergraduate degree and then became a lawyer. And here, years and years later, I'm still back studying philosophy and theology. The student expressed that they weren't sure about what to choose for their topic for an essay in the course, which was on why medieval philosophy is still relevant today. So I decided to record this video to express my thoughts on philosophy and law, in particular medieval philosophy and law. Philosophy as an undergraduate degree is not going to get you into many jobs on its own, but if you think of this degree as changing the way you think, it can be a very good precursor to law school. So, why is it that medieval philosophy is still relevant today? I'll cover several topics here. Um, and not only would these topics be interesting to explore in an essay in a medieval philosophy course, but um, but they also help you understand the development of our legal system and how these topics connect to a career in law. So, first up, there's natural law and its enduring influence on modern jurisprudence. Medieval natural law theories. Um, an example of that would be Thomas Aquinas's Summa Theologica, laid groundwork for contemporary legal concepts of human rights, justice, and universal moral principles. Natural law arguments are still invoked in constitutional law, in international law, and debates about morality of legislation. For a lawyer, understanding natural law isn't just an academic exercise, it's crucial really to grappling um, with the fundamental principles that underpin many legal systems. Arguments that are rooted in natural law show up in constitutional debates, especially concerning what are called unenumerated rights, or the spirit of the law beyond its literal texts. Lawyers dealing with constitutional law, human rights, or civil liberties frequently will encounter arguments about universal moral principles that transcend uh, positive law or man made law. International law and human rights. We've got human rights conventions like the Universal Declaration of Human Rights. These draw implicitly on natural law ideas about inherent human dignity. A lawyer that's practicing international law or human rights advocacy needs to understand how these universal or universalist claims are philosophically justified. Even in contemporary legal discourse, lawyers could invoke natural law concepts to argue for inherent justice or injustice of a particular statute, of a policy, or a judicial system. This is really relevant in areas like bioethics, environmental law, and debates about just fundamental justice. Historically, natural law provides a framework for critiquing and even resisting oppressive regimes by asserting that unjust laws are no law at all. Right? While rarely a direct legal argument today, it informs the ethical stance of lawyers who are working for social justice or challenging discriminatory laws. Then there's the origins of rights and justice as another topic here, from the movement from divine command to secular law. One can trace the historical development of ideas about rights and justice from medieval theological and philosophical discussions to their secularized forms in modern legal systems. Concepts of inherent human dignity and the common good, which are debated in medieval philosophy, transitioned into legal frameworks that protect individual liberties and promote social welfare. So, this topic helps lawyers understand the historical roots of the concepts that they work with daily. Right? You can understand legal evolution. Right? We have, as lawyers, have to. It helps to understand why laws are structured the way they are, tracing concepts of rights from religiously informed medieval thought to secular Enlightenment ideas, provides context for our legal frameworks today. The transition from rights as divinely ordained to rights as inherent to human personhood informs the debates on equality, on religious freedom, and on individual autonomy. Then there's the interpretation of foundational text. Many legal systems, especially those in common law countries, have foundational texts like the Magna Carta, even if it's not strictly medieval, it's influenced by earlier thought. Those texts can be better understood with an appreciation for the historical development of concepts of justice and rights. And also when you get the skill down to read old texts, it can really help you with understanding the legalisms, the legalese that is in older law here in the US. Then there's debates on morality and law. Lawyers often confront cases where legal outcomes clash with public morality. Understanding the historical tension between divine command and secular law can help you navigate these ethical terrains, especially in areas like family law, end of life care, or freedom of conscience. Another area here, another topic is reason, authority, and precedent. Medieval scholasticism, as it's called, and the development of legal reasoning. There's a methodological rigor going on in medieval philosophy of scholasticism, particularly with emphasis on logical argumentation, the reconciliation of contradictory texts, and the use of precedent. I said those things a little bit slower because these are key things going on in law. These medieval intellectual habits contributed very much to development of systematic legal reasoning, case analysis, and hierarchical hierarchical structure of legal authority. So this is definitely one of the most directly applicable topics when you are trying to connect a study of philosophy, in particular medieval philosophy, to a career in law. It speaks to the very method of legal practice. There's case analysis and argumentation, the rigor method of presenting arguments, of anticipating counter arguments and objections and replies, seeking to reconcile contradictory text is very similar to common law legal reasoning, where you are reconciling different outcomes in cases, in written opinions from judges, for example. We routinely engage in this as lawyers. We analyze these previous cases, the precedent, we distinguish the facts, we construct arguments by synthesizing different legal sources. Secondly, there's respect for authority and hierarchy. Medieval thought placed a significant emphasis on established authorities like Aristotle, church fathers, scripture. This reverence there for authoritative texts and interpretation, this arguably paves the way for a legal concept that we have of following precedent called stare decisis. It's this idea that we don't just make new law every time we go into the courtroom. We look back at how the courts have done it. There's a hierarchical structure of court systems where higher court decisions bind future lower court decisions. And thirdly, there's a logical rigor in presenting argument, in particular brief writing. Right? There's a structured syllogistic approach of scholastic debates in medieval philosophy, and this really fosters a culture of, among philosophers and thinkers, of logical precision. Lawyers, in drafting briefs and contracts, legal opinions, if they can employ that similar clarity and logical coherence to building compelling arguments, they're really going to be influential with those who are reading those briefs and those who are hearing those arguments. Another arena where medieval philosophy could connect to the practice of law is the concept of justice, of course, in medieval thought and how it might apply to legal ethics today. There are different medieval understandings of justice um, with relevance to modern legal ethics. Medieval philosophical debates about fairness, proportionality, the purpose of law, those continue to inform professional conduct rules, judicial decision making, um, sentencing guidelines, and the general pursuit of just outcomes in the legal system. So, this topic directly addresses the moral compass of legal practice. Medieval discussions of commutative justice, that is, fair exchange essentially, distributive justice, where you got fair allocation of resources, and legal justice and adherence to the law for the common good. These provide a framework for understanding ethical obligations for lawyers. That includes our duties that we have to clients, to the court, and to society. We also face dilemmas where the letter of the law might conflict with the sense of fairness or moral rectitude, at least the sense that we have or that our clients have. Understanding medieval approaches to justice, like equity and the role of conscience, can offer historical perspectives on navigating these sorts of situations. Many medieval philosophers emphasized the law's role in promoting the common good. So lawyers who were involved in public interest law, often for NGO, nonprofits, non-governmental organizations, involved in policy advocacy or legislative drafting, you can draw upon these sorts of historical ideas to articulate a broader societal purpose for your work. Then there's free will, responsibility, and punishment as a topic. Are these the medieval philosophical foundations for criminal law? There are discussions there on free will, on moral responsibility, the justification of punishment. These provide some foundational concepts for modern criminal law, including the notion in the law what's called mens rea, which is whether the person has a guilty mind, whether they were intending to perform a criminal act, culpability generally, and the aims of incarceration, whether that's retribution, deterrence, rehabilitation, or some combination thereof. So this really does directly relate to the theoretical underpinnings of criminal jurisprudence. Medieval debates on free will and moral culpability lay the groundwork for cornerstones of modern criminal law, like that concept of mens rea, what's in the mind of the criminal. Lawyers who defend or prosecute criminal cases have to understand nuances of intent and knowledge, and whether something is reckless or negligent very much depends on the guilty mind. Medieval thinkers explored different justifications for punishment, as I mentioned. Those same debates continue. They animate sentencing arguments now, parole decisions, sentencing guidelines, discussions about the purpose of incarceration. Lawyers who are involved in criminal defense and prosecution or in judicial roles, you've got to grapple with these sorts of justifications almost daily, perhaps. Philosophical discussions about the capacity for rational choice also, and the nature of mental defect were occurring in the medieval period, and they informed early ideas about legal defenses that related to mental state, capacity and insanity defenses. Uh, and so we have these modern insanity defenses and competency hearings that occur. And so understanding those debates and being able to make those same sort of arguments will really inform you if you find yourself in that sort of legal role. Lastly, I'll talk about the relationship between church and state. There are medieval precedents for modern constitutionalism and separation of powers. Complex power dynamics and philosophical debates were surrounding the relationship between the secular and the ecclesiastical authority in the Middle Ages. there are parallels between these historical struggles and modern constitutional principles, such as separation of powers, religious freedom, limitations on government authority. And this is really critical for understanding the structure and limitations of government power. The historical struggle between powers, ecclesiastical and secular, in the Middle Ages shaped these different constitutional principles, and you can see them in our Establishment Clause and Free Exercise Clause in the US Constitution. If you're a lawyer who specializes in constitutional law or civil liberties, you absolutely have to grasp this historical trajectory. But if you are just interested in the church or in politics or in keeping the church out of politics, this is really a critical study to understand the history that led to where we are and the thinking that led to where we are. Also, in jurisdictional disputes, medieval debates over which authority had jurisdiction over certain matters, in marriage and education, in certain crimes. These are antecedent to modern jurisdictional questions in law, such as between state and federal governments or between different branches of government. And it's still a church and state issue. We've got a thing called an ecclesiastical doctrine, where the church's rule in a wholly inside the church dispute oftentimes will trump the law that the court would otherwise apply. The concept of divinely ordained law being superior to human law lays the groundwork for the notion that even the sovereign's power is not absolute and is subject to higher principles, which is a vital concept in this ecclesiastical doctrine and in constitutionalism and in the rule of law. So that's my take on the importance of studying medieval philosophy if you want to be or already are a law student or a lawyer. Have a great day.